Good afternoon and welcome everyone to K&L Gates webinar, where we will be discussing the SEC proposed exemption from broker-dealer registration for finders in private placements. My name is Eden Rohrer. I'm a partner in K&L Gates New York office. I specialize in broker-dealer regulatory work. I regularly represent broker-dealers and other industry participants on broker-dealer status issues and frequently address issues with respect to finders. I'm joined today by two of my partners in our Boston office, Rich Kerr and Pablo Mann, who will introduce themselves.
My name is Rich Kerr. I am a partner in the Boston office of K&L Gates, where I am a member of the broker-dealer practice group, along with many other things. I'm happy to be here to speak to you about this proposed exemption. Like Eden, I frequently find myself dealing with issues related to finders on behalf of our fund clients and others, and I find that this is going to be if adopted, this exemption is going to be extremely useful in my practice and others. Let's see if we can get Pablo up now.
I'm Pablo Mann. Welcome everybody. I'm in the Boston office. I work closely with Rich and Eden on broker-dealer matters, including Reg BI and Form CRS, but I really focus my practice on Advisor Act issues, and I work closely with private funds on their offerings and private placements. So I have a good experience with issues that are tangential to this new proposed exemption, including the new proposed amendments to the cash solicitation rule under the Advisors Act, and general private placement and general solicitation questions in the context of Regulation D and otherwise. So I am looking forward to this discussion that we're going to have, and I'll turn it back over to Eden.
Great. Thank you, Rich and Pablo. So let's start. Why are we here? We're here to discuss a proposal that the SEC made on October 2020. It was last Wednesday at an open meeting. The SEC proposed a conditional exemption for finders from the requirements to register as a broker-dealer or as a broker under Section 15A of the Securities Exchange Act. Now, this proposal would permit natural persons only, not entities, to engage in certain limited activities on behalf of issuers in connection with private placement offerings. It would operate as a non-exclusive safe harbor, similar to other safe harbors that we'll discuss later. And it is what we believe is a groundbreaking proposal, very unexpected from the SEC. Some of these, the SEC indicated that they've been getting quite a bit of questions, both from the industry and from the bar, about the parameters of finders exemptions. What is a finder? What does it mean? How can they operate within the securities laws? And so it's surprising, and we'll talk about that later. You can also access our client alert called Finders Keepers, SEC proposed exemptions from broker-dealer registration, that we published on October 13 and is available on our hub page. Now, to get us grounded, Rich Kerr is going to describe the statutory requirements related to broker registration, and then we're going to discuss the proposal itself, how it compares to several existing exemptions, and then if we have time, and the questions that it raises. And then if we have time, we're going to address questions. So I invite you to use the chat feature in the WebEx, and if we have time, we'll address some of those questions. So Rich, why don't you lead us off on statutory requirements?
Great, thank you, Eden. So, before we can, talk about a proposed exemption from registration as a broker, we thought it might make sense to, talk about, when and why someone might be required to register. A little bit of background, but it'll help in educate the discussion later on. So, as noted up on the slide here, any broker or dealer that engages in the business of affecting transactions and securities for others is required to register with the SEC as a broker-dealer, unless they are engaging, so they're either exempt on their own, pursuant to an exemption such as the proposed exemption we're going to talk about today, or the securities that they're affecting transactions in are exempted securities. For example, bank-maintained collective investment trusts are exempted securities and can be sold by persons who are not registered as a broker. Next slide, please. Section 15A1 says that a broker must register if they're engaged in those activities. So, what is a broker for purposes of the Exchange Act, and why would somebody who's acting in a finding capacity be required to register? So, this term has been broadly construed over many years by the SEC, and to mean any person who participates in integral or important parts of a securities transaction. So it is not solely the activity of executing the transaction, such as a transaction on an exchange or submitting an order to to purchase a security. So when we consider who is acting as a broker, what we need to determine is the degree to which they are involved in the transaction, as well as whether their compensation is transaction related, which has been determined by or stated by the SEC to be sort of the hallmark of broker-dealer activity. Under this, this broad definition, many entities or persons who you would not typically think about as a broker-dealer have historically been required to either register as a broker-dealer or engage a third-party broker-dealer to assist them in executing transactions. For example, under this definition, many investment advisors or financial consultants have had to either register or associate with a broker-dealer. Persons that acting as placement agents, banks, to the extent that they can't comply with the exemption under regulation, are. So if we can move to the next slide, please. So what does it mean to be engaged in the business of affecting transactions and securities? This is sort of, a degrees question. The SEC in a number of interpretations has given us some indications as to what that might mean. The first is, does one hold themselves out as being, available to execute transactions in securities on behalf of the accounts of others? And not only do they hold themselves out, do they solicit that business? Are they soliciting persons to use them to engage in transactions? Again, we talked about it on the last slide, but how are they compensated? Is their compensation dependent on the execution of the transaction? When we look at this, we look not only at whether there's a flat commission tied to the transaction, but whether they may, the amount of their compensation is in fact dependent on the transaction. For example, in some cases, a bonus compensation may trigger a determination that it's transaction-based compensation. So the point of this whole discussion is that persons who are engaged in important parts of securities transactions, who receive compensation associated with those transactions and hold themselves out to be available to execute those transactions or be involved, generally would be considered to be brokers. Now, I think if we go to the next slide, what we're going to see is, why would a finder, or I guess we're going to talk more about affecting transactions in securities here. And I'm not going to read these to you, but affecting transactions in securities, again, is not simply the execution of the transaction. There are important parts of the transaction, including identifying persons who may wish to participate in a transaction, filling out paperwork, preparing, in some cases, preparing marketing material for an issuer, consulting with an issuer with respect to their desire to sell a security. All of these, these activities may lead to a determination that the broker or the person involved is engaged in the business of affecting transactions in securities. Next slide, please. So, what is a finder, and why is this exemption important to us? Well, historically, the federal securities laws have not had any formal definition of a finder. There has been a couple of relevant no-action letters over the years which have discussed the concept of a finder, none of which have established a blanket exemption or no-action relief upon which finders who engage in any proactive discussion with potential investors can rely on to avoid registration as a broker-dealer. But a finder is generally understood to be a individual or entity that assists brokers with finding investors or customers for making referrals to the customers, and making referrals of customers to a broker. In many cases, providing lists of prospects to either a broker or an issuer. All of these activities, when tied to compensation that can be considered to be transaction-based, have resulted in, a determination that those finders have registration requirements under Section 15A1 and should be treated as brokers. In fact, there have been, a number of enforcement proceedings over the years where persons who you and I would not generally consider to be acting as broker-dealers have been found to have been acting as unregistered brokers, and for engaging in, activities that we would generally think of as, providing simple referrals or lists of potential investors, et cetera. The last thing I want to say on this, because I think we're going to talk about, the concept of what is a finder, or at least what a finder will be under the proposed exemption going forward, is that several states have adopted finders laws. We referenced a couple of them on here. There may be some others as well. When and if the proposed exemption that we talk about today is finally adopted, those finders laws will continue to be in existence, and as such, so a finder, who can qualify for the proposed exemption from SEC registration, may in fact still find themselves having to register or at least consider the registration and regulation requirements in the states in which they operate. Next slide, please. And Eden is going to, or I think Pablo is going to give us a short summary of what in fact the proposal is.
Thanks, Rich. Yeah, so with that background, let's delve in and see what we have here from the SEC. There were a lot of materials that were published when this first came out. There was initially the open meeting, which was broadcast by webcast. was available to the public. And soon after that came the proposing release, which was issued. There were a number of statements from Chairman Clayton and Commissioner Pierce, Commissioner Roisman in support of the proposal. But what else do we have? We also had two very strong dissents in terms of the adoption, which, and I'll talk about this in a second, call into question if or when and how the proposal might be adopted. Now, the other thing, though, is that the comment period for this proposal is very short. It's just 30 days. And very soon, so the open meeting happened on October 7th, and the proposing release came out October 7th. Already by October 13th, it had been published in the Federal Register, which started ticking the 30-day clock on that comment period, which will expire on November 12th. And so, compared to other rule proposals or adoptions where it might be months or over a month for things to get published in the Federal Register, this was very, very quick. And so there's a short comment period that the clock is ticking on right now, and two strong dissents from the commission. So we'll see what happens with this. There was also, and I should just note, if you go on the SEC's website, a video and a handy chart that compares the finder's exemption and what that allows versus what brokers can do. And it's a handy little guide which you can access online. Next slide, please. So the proposed exemption would create two tiers of finders, Tier 1 and Tier 2, and they're defined and regulated differently because of the level and extent and frequency of the activities that they can conduct on behalf of issuers. So Tier 2 finders will be able to do more, but they'll also be subject to more requirements. The proposed exemption is limited just to natural persons, so not entities. And it will allow finders to, as we've been talking about, assist in capital raising activities on behalf of issuers in the context of private placements. And we'll talk about this a little bit later as well, compared to some of the existing exemption that we have for private funds, which is the issuer exemption, which prohibits the receipt of transaction-based compensation. This allows the natural person to get transaction-based compensation, and that's why this is a bigger deal. And as we've talked about, this is a conditional exemption. So it functions as a non-exclusive safe harbor, but it is a conditional exemption. Next slide, please. So when can finders take advantage of this exemption? The exemption is really only available to finders that participate in certain types of offerings. First of all, the issuer is not permitted to file, or is not required, I should say. This is an important distinction. It's not required to file reports under Section 13 or 15 of the Exchange Act. The offering of the securities is conducted in reliance on an applicable exemption from registration under the Securities Act. So this would be Regulation D, Regulation S potentially, and the finder does not engage in a general solicitation. The potential investor has to be an accredited investor, and this is similar to the 506B standard. The finder has to have a reasonable belief that the potential investor is an accredited investor. So there's no 506C sort of verification requirement. It's a reasonable belief standard. The finder has to provide its services pursuant to an agreement with the issuer that includes a description of the services that are to be provided and the compensation. And the finder cannot be an associated person of a broker-dealer. So if the natural person is an associated person of a broker-dealer, then the exemption is not available. And the finder is not subject to certain statutory disqualifications under the Exchange Act. Next slide. Finders, and this includes both Tier 1 and Tier 2 finders, would not be permitted to do certain things. And these are things that in the private fund context, particularly in smaller managers, finders might do as well, which could raise an issue, that we can discuss later, and we'll discuss later in the context of the issuer's exemption. But keep this in mind, that this might be helpful more in the context of small companies and not necessarily in that private fund context. But finders would not be permitted to participate in the structuring of the transaction or negotiating the terms of the offering, handle customer funds or securities, bind the issuer or the investor, participate in the preparation of sales material, perform independent analysis of the sale or engage in diligence activities, assist or provide financing, or provide advice as to valuation or financial advisability of the investment. So I do think, from these general restrictions, it is going to be a challenge, I think, particularly for managers where the sales team is doing a lot and has a lot of different hats. But, potentially is useful for larger managers that have dedicated sales teams that don't participate in the preparation of the sales materials. So that's a little odd. Or potentially if you're an advisor and you have someone perhaps on the investment side that has a lot of contacts and you want to take advantage of that, it could be useful. But there are limitations here that make this proposed exemption a little bit limited. Next slide, please. And so with that, let me turn it back over to Eden to talk about the two types of finders and go into a little bit more detail about those.
Thanks, Pablo. Let's talk about Tier 1 finders. So Tier 1 finders are more limited in the activities that they can conduct. They can only provide contact information of potential investors to the issuer. They can only engage in a single capital raising transaction by a single issuer in any 12-month period. They may not have contact with a potential investor about the issuer. And the Tier 1 finder essentially codifies an existing SEC no-action letter, the Paul Anka no-action letter that was published in 1991. Now, you may recall the entertainer, and the popular entertainer in the 70s, Paul Anka. Depending on your musical tastes, he was famous for, among other things, a truly terrible or wonderful song called Havin' My Baby. But I digress. It's just sort of a wonderful collision of pop music and sports and securities law that doesn't really happen very often. So Paul Anka was permitted to to assist the Ottawa Senators hockey team to raise money in an offering by simply providing a list to the team and not having any contact with those investors. And he could only do it once. What's interesting is the Tier 1 Finders exemption codifies that letter, but it changes it a little bit because the Tier 1 Finder can participate in a capital raising transaction every year, for instance. whereas Paul Anka indicated, or one of the conditions of that letter was that he would only do that once. There's not surprising that this release, that the Paul Anka letter was included in the exemption for finders. Next slide, please. More surprising, though, was the Tier 2 finders, who are permitted to engage in a much broader number of activities. A Tier 2 finder could participate in multiple offerings in a given year, can have contact with potential investors, and the activities that a Tier 2 finder is permitted to engage in include identifying, screening, and contacting potential investors, distributing offering materials, discussing issuer information, arranging and participating meetings with the issuer and the investor. Next slide, please. So because the Tier 2 finders are permitted to engage in more activities than a Tier 1 finder, they're also subject to heightened conditions. And they must provide a disclosure to any potential investor prior to or at the time of the solicitation. Now, this disclosure is similar to the cash solicitation rule for investment advisors, which we'll talk about later. And so the disclosure includes the name of the finder, the issuer, description of the relationship between the Tier 2 finder and the issuer, including any affiliation. This is interesting. We'll talk about this a little bit later as to whether the Tier 2 finder can be affiliated with the issuer as, for instance, an employee, a director, or an officer. The disclosure must include a statement that the Tier 2 finder will be compensated and a description of the terms of that compensation, any material conflicts in the arrangement or with respect to the relationship, and an affirmative statement that the finder is acting as an agent of the issuer, is not acting as an associated person of a broker-dealer, and is not undertaking a role to act in the investor's best interest. Then the Tier 2 finder must obtain prior to or at the time of the investment a written dated acknowledgement from the investor acknowledging the receipt of the disclosures. Next slide, please. So why are we referring to this proposal as groundbreaking? As I said, it's not a surprise that the proposal included something similar to the SEC no action release to Paul Anka, although frankly, that's for years industry and the bar have been lobbying for some clarification on that issue. More surprising is how is the Tier 2 finder exemption. Now, we've talked about the SEC has not previously defined the term finder. The SEC has consistently refused to allow unregistered intermediaries and has taken enforcement action, usually in the context of fraud, but there are some cases where the only violation was with respect to the status of the broker. There's no notice or registration requirement to take advantage of this exemption. It operates as a safe harbor. So if the finder operates within the parameters of the safe harbor, then they would not be required to register as broker-dealer. And there's no notice to the SEC that they would be acting under the exemption. The commissioners who dissented, Commissioners Crenshaw and Lee, I believe, noticed that and that there was no notice provision or registration requirement. And that's inconsistent with other recommendations from time to time that have been made to the SEC. It's inconsistent with some of the state's laws that require a registration for a finder under the state's laws. Also, the proposal, we'll talk about this a little bit later, but the proposal allows offerings where the issuer is not required to file reports under sections 13 or 15, and that leaves the door open potentially for finders who participate in private placements for OTC microcap issuers. We'll talk about the inconsistencies with the solicitor rule. This is an interesting proposal because it's a proposed exemption rather than rulemaking. And we talked about the inconsistency with states' rules. So, Pablo, why don't you talk about the comparison with the issuer's exemption? Next slide, please.
So, Eden, I think I was actually going to take that one. But before we move on to dealing with the comparisons, while you were speaking, we did get a couple of questions in the chat that I think make sense to answer now while the conditions to the exemption, then proposed exemption, are fresh in everybody's mind. And so I'd like to ask, you, since you just described it, what happens if a finder violates the conditions of the exemption? What would be the ramifications to the issuer or the offering itself? And so I'll pause there and let you answer.
Sure, it's a great question. So the way a safe harbor operates, and a dear friend of mine who is on the web call once explained it to me, that safe harbor operates that if you comply with all of the conditions of the exemption, you're swimming inside the ropes, right? And if you don't comply with them all, you're swimming further outside the safe area, right? But still, under the securities laws, all of the facts and circumstances might not lead to the conclusion that you are operating as a broker. So first, let's keep in mind the safe harbor and how that works. So you're safe by operating within the conditions, but once you don't comply with all of the conditions, you're at risk for broker status. Now, an issuer who engages an unregistered finder who should have registered could be subject to rights of rescission from those investors. The finder, him or herself, could be subject to SEC enforcement action. And other participants under state law, federal or state law, other participants to the transaction could also be subject to penalties for having aided and abetted that violation of the securities laws.
Great. Thank you, Eden. I thought it made sense to answer that question here before we got into the various questions that remain. There's at least one other question in the chat that I'm going to hold to the end because I think it does bear on what we're going to discuss, towards the latter part of this presentation regarding, whether this should be applicable to certain types of transactions beyond private placements. So we're going to move from one proposed safe harbor to another. Rule 3A41 under the Exchange Act has established a safe harbor that many issuers use when their associated persons wish to participate or they desire their associated persons to participate in the, in an offering, in introducing investors to an offering. In order to comply with Rule 3A41, all the conditions of the rule must be met. And if done so, as Eden just described with respect to the proposed exemption here, if all the conditions to 3A41 are complied with, the associated person of the issuer will not be deemed to be a broker and not be required to either register or associate themselves with a broker. And so what are those conditions? And you might ask, are they consistent with this proposed exemption or are they different? Well, the first one I think is a no-brainer. As when you look at the slide, obviously the person cannot have a statutory disqualification under the Exchange Act that would have prevented them from being a broker. There is no transaction-based compensation allowed. So the understanding, the writing behind Rule 3A41, makes clear that the staff's view in adopting Rule 3A41 was to permit, this type of activity to be done sort of as, tangential to their regular, role with the issuer. So you're looking you've got a board member who may introduce an investor, or you get an officer who may, call a potential investor because they know that they've expressed an interest in investing previously. But their compensation is not permitted to be tied to that activity on behalf of the issuer. And lastly, I said that they're not only are these persons associated with the issuer, they cannot be associated persons of a broker-dealer. So for example, an employee of a broker could not, outside of his capacity as an employee of that or a registered rep of that broker-dealer, could not introduce investors to an issuer and rely on Rule 3841 to have it not be subject to broker-dealer regulation. Now, this question, that question, not associated persons of a broker-dealer, has come up in many contexts where a firm may be a sponsor of a private fund, and somewhere in the overall organization, they have an affiliated broker-dealer, even an affiliated broker-dealer that might be a limited purpose in nature and would not be permitted to assist them in offering the private fund. In that case, this aspect of the rule, knocks the private fund from being able to, have employees or officers rely on the issuer's exemption to introduce investors. So, why is this, why are we talking about the issuer's exemption here? We find it interesting and worthy of discussion as to why there are differences between the two. Because if, to the extent there were some modifications to the proposal, the proposed exemption may be a worthwhile tool in the belt of certain issuers who may not have to comply on Rule 3841 for future offerings. So, however, there are key differences, and we want to note them here. First, unlike the proposal for finders, we've got the person who's relying on the issuer's exemption is permitted, because of their role with the employer, to engage in certain activities that a finder would not. They're permitted to structure and negotiate the offering. They can handle customer funds, facilitate the execution of the transaction, and provide analysis to the potential investor. However, it is in doing so, it is sort of the expectation that it is being done in the context of or their role other than introducing the investor for the issuer. The issuer's exemption also does not permit persons to sort of routinely engage in this type of activity on behalf of the issuer. Rather it's, again, it's expected to be, a one-off type basis. And in fact, the rule includes a limitation that they can only participate, in an offering, in one offering per 12-month period. So this would not be an ongoing piece of, under the issuer's exemption, you're not able to have this be an ongoing component of your associated person's day-to-day activities. Whereas, a finder couldn't do this under the proposed exemption, will be permitted to do it on a repeated basis, subject to their agreement with the issuer. So I want to move on here, but we think this is there are important distinctions between these two safe harbors that may sort of be worthy of certain industry participants to think about, and perhaps, although albeit a short comment period, perhaps make their views aware to the SEC. If nothing else, we would like to see clarification as to, as to when an issuer may have an associated person of the issuer be considered a finder and not be relying on Rule 3841. Next slide, please. I think we're going to Pablo talk about, the cash solicitation rule.
Thanks, Rich. So last year, the SEC proposed amendments to the cash solicitation rule that's currently in effect. These are important amendments which will affect the way that solicitations are conducted for investment advisors with respect to their private funds. Because under the current rule, the solicitation rule only applies to the solicitation of advisory clients. And we know that, and there's no action relief on this point, that the solicitation of investors in private funds is not deemed to be the solicitation of advisory clients. And so when an investment advisor engages a broker-dealer to act as a placement agent for one of its private funds, those solicitations are not subject to the cash solicitation rule. The amendments, what those would do is they would add solicitations of private fund investors to be subject to the rule. And so the effect of that is that potentially a solicitor would have to comply with the Advisors Act amendments to the solicitation rule if they're adopted as proposed, and the fact that this exemption is being proposed and the SEC has asked questions about it seems to suggest that it might be. And it also creates obligations for advisors that hire solicitors to find investors for those private funds. So what are some similarities? What are some differences? How does this affect investment advisors? How does it affect finders? So advisors that have to comply with the amendments to the solicitation rule, they're going to have a lot of overlapping obligations with respect to making sure that the solicitors are doing certain things. And one of those things is similar to the finder's exemption. There are disclosures that solicitors have to provide to those investors, particularly the Tier 2 finders. They're not identical, but they are pretty similar. Solicitors would have to disclose material conflicts. They would have to disclose their compensation. They would have to disclose the relationship between the solicitor and the investment advisor. So not the issuer, but the investment advisor. They would not, however, under the solicitation rule, have to include this very clear statement that's in the finder's exemption about acting as an agent for the issuer and not acting in the best interest of investors. So just because you have a solicitor that complies with the disclosure obligations of the proposed solicitation rule doesn't mean that they're squarely within the framework of what's required for Tier 2 finder disclosures. And the other question that this new proposal raises is, what about an advisor's oversight obligations of solicitors? So under the proposed solicitation rule, advisors have to have a reasonable belief and have to have a sense that solicitors are complying with the solicitation rule. And under the current framework, there's usually a level of oversight or comfort that managers take in knowing that the solicitors are registered broker-dealers. When the solicitor is not registered as a broker-dealer because they're going to be relying on this proposed exemption, it raises some questions for the manager and things to think about in terms of those agreements for making sure or at least reviewing or taking into account the basis for the solicitor not being registered. Eden talked about before the enforcement actions that have been in this space, and one of those enforcement actions is Ranieri Partners, where a manager was essentially viewed as having aided and abetted an unregistered solicitor. So it is something that managers will have to be mindful of, where a lot of the placement agreements right now will just say that the solicitor or the placement agent is a registered broker-dealer. If they're not, then what is the basis for that exemption, and how does the manager get comfortable that they're not engaging a solicitor that should be registered as a broker-dealer? These are questions, particularly the issue on disclosure, that the SEC is aware of. In the proposing release, they asked specifically whether the disclosure obligations under the finder's exemption should align with the disclosure obligations in this proposed solicitation rule, if it's adopted as proposed, and vice versa, whether the fact that you have complied with the solicitation rule disclosure or the finder's exemption disclosures should mean that you've complied with the other disclosure obligation. And with that, I think next slide, and Eden will talk a little bit about the angel investor platforms and microcap issuers.
Sure. So we talked about several other exemptions for intermediaries to securities transactions not being required to register. Another is Title II of the Jobs Act. So Title II is commonly referred to as angel investor platforms, and that allows an online investment portal to operate and not register as a broker-dealer, provided it's not receiving transaction-based compensation. Remember, the hallmark of broker status, doesn't have possession of customer funds or securities, is not subject to statutory disqualifications. It applies only to Rule 506 offerings. The angel investor is permitted to co-invest in securities, and the angel investor is permitted to provide ancillary services but not advice. And so this is distinguished from the proposed finder's exemption because of the limitation on transaction-based compensation, but also the services that the platform is allowed to offer are very limited to, I believe it's providing some documentation, but limited services. The finder exemption much broader. Next slide, please. One issue I want to raise, and I found it curious that the proposed exemption is limited to offerings for issuers who are not required to file reports under Section 13 and 15 of the Exchange Act. In contrast, the securities listed on stock exchanges, microcap securities listed on some of the over-the-counter markets can trade without being registered with the SEC and therefore not subject to Section 13 and 15 requirements. The over-the-counter requires some of those issuers to voluntarily report and make those filings subject to different tiers of those markets on the over-the-counter markets, but they're not required to. And I found that surprising because the SEC has prioritized fraud in the microcap industry, particularly with respect to unregistered intermediaries who are engaging in private placements or underwritings with respect to that industry. Next slide, please. Open questions. So we had a question whether a finder can engage in general solicitation under 506C. And it seems that Reg D 506C allows for general solicitation, but a finder would not be able to engage in the general solicitation. It's unclear whether in that same offering, I would assume the issuer perhaps could engage in general solicitation, but the finder would not be able to do that. So, open questions. The definition as proposed for finders is limited to natural persons. And the SEC, first let me backtrack. The SEC in the proposed release outlined 45 specific questions, and Chairman Clayton in his open statement focused on some of those questions. And so it seems as if the SEC is truly trying to enlist the industry to address those questions, and they are considering some of those issues. So the form of the proposed exemption as it exists now may or may not be the same as what is adopted. And so questions, the SEC raised questions as to the finder. Now, we had a question about the M&A broker's letter and how the proposed exemption operates within the M&A broker's letter. Now, the SEC specifically referred to it in the questions and queried whether the SEC should consider codifying the M&A broker's letter, and also if the finder's exemption is adopted, whether there are any SEC staff no action letters that should be withdrawn. Now, the M&A broker's letter is different than the proposal for finders because M&A brokers are not permitted to assist an issuer in raising capital. And so, there's some overlap, but there are distinctions between the two. And so an intermediary, could an intermediary rely on both in the context of a single offering? It's an interesting question. So, Rich or Pablo, do you want to discuss any of the particular questions or answer any questions that are on our that have been submitted by our audience?
So, I found it interesting that the staff would propose this exemption and I think by their own admission, knowing that they didn't have all the answers with respect to how it should work. It's a very short exemption for which they have listed out 45 plus questions at the end that they'd like the industry to consider and perhaps comment on. We've highlighted a few of them here, but I think just by their own admission, they know there's a lot of questions here. The one area which I think came up earlier in Pablo's discussion that I'm interested in and been thinking a lot about is whether or not there should be any notice filing or other requirement of a person acting as a finder or even perhaps just a tier 2 finder to effectively notify the SEC that they're engaged in this business and allow some minimal level of regulation or oversight. I think some of the trade groups are particularly concerned and focused on that as well, and may look to comment on it because I think what we're afraid of is sort of having this situation where we've got a bunch of finders run amok and nobody knows who they are. I think that's an important point to consider. That while I think it is a useful and as we went to groundbreaking step on the part of the SEC to acknowledge that certain persons can perform this role without having to register. I do think that there may be a view, from participants in the industry, both broker dealers and otherwise, that perhaps there should be some, way of identifying who is an active user and who has entered into contracts to do so.
Sure. Rich, it occurs to me that with respect to the Form D that's filed with respect to Reg D offerings, that those Form Ds do list whether any compensation has been paid. I don't know if that's the intention of the SEC or if the lack of a notice requirement is somehow recognizing that fact.
No, I think that's a great sort of analogy in that there could be a minimal notice reporting requirement, such that when you're entering into a contract with a finder, you could check to make sure that they had in fact performed their notice filing. And we've got a handful. We've only got a few minutes left, and we've gotten a handful of additional questions that I think it might make sense to try to answer before we close. And I think the first one that I'd like to talk about, and then maybe throw it, is that we've got a question regarding what is the likelihood of this proposal being adopted under the current or next administration. And I think that's a very in my view, I think that is a very sort of intuitive type question to ask. Going back to 4 years ago when Chairman Clayton first took his role, he's made it clear that his priority was to increase access to capital to the Main Street investors within the confines of SEC regulation. I think that he and other members of his staff are viewing this as one more step in that chain that they would like to get done before perhaps some of them leave office towards the end of the year. And so I think that there is by issuing it when they did, creating a short comment period of only 30 days, and publishing in the Fed Register within a week of having issued the proposal. I think that there is it's a clear intention of the current administration that they'd like to get this done, before, in the very near future, and not let it roll over into a new administration if there is one. However, I think it's not a slam dunk. As we've noted, there's a lot of questions that still need to be answered. We would expect there would be lots of comment letters filed within that 30-day period. And we've got two commissioners who have indicated their strong dissent to the proposal in its current form. Unlikely that if the SEC or if the staff comes back with a final rule that looks a lot like the current proposed exemption, that those two commissioners' views are going to change. So I think that there's some headwinds to it getting adopted, but I think there's sort of a political reality that it seems like the current regime at the SEC would like to, have this be one of their, their achievements before year end.
Yeah, and there's a question about whether the SEC anticipates pushback from broker-dealers on this proposal. It's possible. Some broker-dealers would view this as anti-competitive. We had to register and we have to comply with all the obligations, and if these finders are not required to do that, and that puts us at a competitive disadvantage. We might see comments to that effect. Also, certain broker-dealers may decide to deregister and take advantage solely of the finder's exemption, particularly perhaps capital acquisition brokers whose activities are limited, and other brokerage firms who are no longer interested, for instance, in dealing with retail investors and complying with regulation best interest, which there puts more compliance obligations on them. Other broker-dealers, I find whenever there's a new rule like or an exemption like the M&A broker's letter, broker-dealers consider how can we use this to our advantage, and consider ways, whether there's an affiliate, whether there's, how can we take advantage of this proposal and use it for our business.
I think that's great. We are out of time. I just wanted to briefly mention, under regulation best interest, broker-dealers have this obligation, and that's very clear from the staff guidance, that even if you're a limited purpose broker-dealer, basically placing interest just for accredited investors. You're still subject to regulation best interest. But in due registering, I think people will need to be mindful that even as proposed, this finder's exemption applies only to natural persons. And so, that will be an interesting dynamic to keep in mind as well.
Exactly. And that was one of the questions that the SEC posed, whether it should be limited to natural persons or whether it would be available to entities like the M&A brokers letter. Yes, all really interesting questions, interesting proposal. We're excited and we'll be following how this progresses. The industry is encouraged to submit comment letters. The SEC wants to hear from industry, and we'll be following all of those developments. So thank you for joining us today. We were glad that everybody joined and submitted questions, some interesting questions out there. And if you have additional questions, feel free to get in touch with the three of us. Thanks very much, everyone.